So just briefly, the organization that I work for is called the Canadian Centre for Elder Law. It's part of the BC Law Institute, which is BC's nonprofit law reform agency. We're different from Seniors First BC, and Nagat and Marie Noel today, who are the second and third speaker, are from Seniors First BC. They do advocacy, but our office doesn't do advocacy. We do publish resources and do a lot of presentations and such to help folks understand the law. We produce some educational tools, and we try to change laws for the better. We put everything on our website for free. So there's a link to our website on the slides. And what I said to Lois is she can share a PDF of my slides with you all after this so that you'll have hyperlinks to everything. I just included this slide here to give you hyperlinks to the web pages for some of the other projects we're working on in case it's of interest. And I'm not going to talk about these different projects in the interest of time. And I wanted to mention briefly that this year we launched a new website called the Practical Guide to Elder Abuse and Neglect Law in Canada, which has information on all different parts of the law that apply to abuse and neglect response. I'm not going to be talking about that today, but it's, I think, a really helpful resource to you folks because it's regularly updated. It's a website, not a PDF. It's available in English and French. So I encourage you to look at it in your own time. And if you have questions, feel free to send me an email. So capacity and decision making. So what is consent? So consent is voluntary, timely agreement to something. The right to consent always includes the right to say no as well, right? If you have the capacity to make your own decisions, that right is only a meaningful right if you can say yes, no, or change your mind later on. In order to have the right to make your own decisions, you need to have capacity. And capacity is a legal word that means basically the ability to understand the information relevant to that kind of decision and apply it to your own situation to make your own choice for yourself. Capacity is domain or decision specific. And what that means is that very few people are going to have not have capacity to make all of their decisions, right? The right to make your own decision about something depends on if you can understand the information relevant to that choice. So capacity is always decision specific, or sometimes we say it's domain specific. Say a person just doesn't understand money anymore or numbers. They might lose their decision-making capacity for financial stuff and have a property guardian put in place for them. But most people have the ability to make their own decisions. And a person with capacity is entitled to make their own choices, even if other people think their choice is unwise or risky or stupid or just not a good idea. If you understand stuff, you make your own decisions. So you want to always consider capacity for what when you're thinking about decision making. And so in this slide, cute little emoticons, there are so many different kinds of decisions that we make in our day-to-day lives. And if no one's ever questioned your capacity, maybe you don't have a disability, you're a younger person, you aren't known to use substances or have a mental health issue, maybe nobody's ever questioned whether you understand enough to make your own decisions. But we make decisions all the time. So here are some examples. So make a healthcare decision, make your own will, sell real estate, decide you want to be part of a research project, contribute to research, have intimate relations, right? In long-term care, the choice to have sex is sometimes something younger people try to take away from people. Get married, create an advance directive, or maybe get a representation agreement so you can choose someone to make certain decisions for you, enter a contract, invest your money, hire a lawyer and instruct them. So there are all sorts of different kinds of decisions, and very few people are going to not have the right to do any of this stuff. They might lose the right to make some kinds of decisions because there's some things they can't understand. And if I had to put all of these on like a continuum of what you need to understand, some rights, it's very hard to lose. Legal community, we often joke that the capacity to get married is, can you say yes? Like the capacity is very, very low. But in comparison to make a will, You need to understand all your different kind of property, who might be potential beneficiaries, who could challenge your will. The capacity standard's quite high. It's easier to lose that one, but good luck losing the capacity to marry. So all adults are presumed to be capable regardless of age or disability, and this is really important. And you see this statement embedded in many different laws in BC. For example, the Adult Guardianship Act, the healthcare consent legislation that I'm going to talk about in a moment, care facility admission. For everyone, you start with a presumption of capacity, and that's why we call it incapability assessment. If anybody ever says they're going to be a capacity assessment of someone, they're using the wrong words, because we assess incapability because capacity is always presumed. So, and I feel like that word is really important. So every time I hear somebody say capacity assessment, and I even forget occasionally, I say, nope, I'm just going to interrupt you and say incapability assessment, right? We don't assess capacity. It's presumed under every law that talks about capacity. So just some very briefly, some basics about capacity before we jump into care facility admission. It can vary, right? So because it's all about what you understand, unless somebody's gone to court and got a committeeship, which is the BC word for guardianship, then your capacity might vary. You might have days that you can make decisions and you can't, because a lot of people with disability have a fluctuating ability to understand. So capacity can vary for some people. Consent must be ongoing. In most cases, people can change their mind, right? Like if you consent to treatment, but then you do a bit of research and you're like, actually, I don't want to do that operation. I've decided my doctor recommends chemotherapy, but I don't want to go through that again. You can change your mind if you understand what's going on and can make informed consent. Capacity is linked to personal supports. And what's important about that is, particularly for people with some kinds of intellectual disabilities, is we don't make decisions by ourselves. Decision-making is really social. So when an incapability assessment happens, it's made in the context of the support available to you. Now, for example, somebody in my family recently who has expressive aphasia, so they have a lot of problems with words. They have a legal case and someone was trying to take away their ability to direct their case. And I said, well, hey, I can come to meetings and listen, and I know exactly what he means when he says dinosaur. He means document, or I can interpret for him. And so he can keep his ability to instruct counsel with my help. So he still has his capacity to make those kind of decisions and participate in litigation, because the assessment of his ability was made in the context of the personal supports available to him. This is where it's really challenging for people who don't have anyone. But for those of us who do have someone who can help us, we're entitled to their support whenever they want to give it to us, as long as the relationship is not abusive. So again, just to highlight that capacity is not about, it's not about risk, right? What often happens with people with disabilities, older adults, is a family member swoops in and is like, I want to make the decision for them. And I say they can't live in long-term care because they might fall down and break a hip. There's risk. Risk is a part of life, right? But that person says, I know I might fall down, but my independence is important to me. I want to live at home with home support. They can make that decision. It's okay if there's risk, as long as they have they understand that risk and make an informed decision. Capacity is also not about best interests. If there's a substitute decision maker who's been given authority to make decisions for a person who cannot make decisions, they have to consider best interests and also other things. But I can make a decision that's not in my best interest. If I have capacity, I can gamble away my money, do terrible things, put myself at risk. None of this stuff really matters if you have your own capacity. But those kind of ideas are used to control other people all the time. So let's talk about admission to long-term care. You can see that where it's blue, there are hyperlinks to documents. So when you get my slides, you can go straight to these documents. But I wanted to highlight things that are important to understanding long-term care admission policy in BC. So there's the Community Care and Assisted Living Act, which is basically the law that governs long-term care and assisted living in BC, but it's really just the nuts and bolts. There's not a lot of detail in there. The juice, the detail is in the residential care regulation. That's where you find more of the details about people's rights in long-term care. And that's where you'll find the rules about abuse and neglect response, about use of chemical restraints, all the kind of juicy stuff. Except it is that there is a schedule to the Community Care and Assisted Living Act, is the Patient's Bill of Rights. That's a really useful thing to get familiar with. The rules about admission to long-term care are mostly in Part 3 of this third law, the Healthcare Consent and Care Facility Admission Act. And then there's two resources that are useful. They are produced by the Ministry of Health. They're the practice guidelines, and they're two-page cheat sheet. They do have some stuff that's not law, and that's their policy. And I know because all of you do, most of you do welfare advocacy, you understand the difference between law and policy and how you need to be rigorous in comparing the two. There's some extra stuff in the policy. I'm going to talk about the law. So just to understand healthcare decision-making generally, because the healthcare consent and care facility admission provisions are both together in the same law. The basic principle is that if you have capacity, you make your own decision. You can do advanced planning and pick somebody to make decisions for you in the future if you can't make them for yourself. In healthcare, we usually call that a representation agreement. Someone can go to court and get a guardian for you. If they say you can't make decisions for yourself, this hardly ever happens because it's expensive. And then if you're in the hospital and you're bleeding on the table and you can't consent for yourself and you don't have a representative and you don't have a guardian, the physician can choose somebody in a default list of family members to make decisions for you. We call those people temporary substitute decision maker. They don't have any long-term rights. They really just are making decisions when nobody else can. This kind of matters because there's a similar framework for care facility admission decisions. So what it means in BC is that we have, like in other provinces, we have independent decision-making for those who can do it, substitute decision-making for those who cannot, and in between, we all get to make decisions with the support from people we trust if we have people in our lives. So in 2019, we got this new framework for care facility admission. It was really important because there was this gap in the law where previously, if somebody hadn't chosen someone in advance to make care facility admission decisions for them, and they couldn't make decisions, and no one's gone to court, who could consent for them? And what was happening was people were getting involuntarily committed under the Mental Health Act to get people into facilities. So they'd commit them under the Act and then release them to the long-term care facility under extended care provision, under extended leave provisions, which is not why mental health legislation exists. And it was a very problematic policy thing happening. So the hope is that this new legislation allows people to choose who will consent for them and gives the system options when they haven't done so that don't involve using the Mental Health Act. But I do know that sometimes the Mental Health Act is still being used. So the new legislation, it defines what a care facility is, it sets out informed consent rights, and it says who can consent if the person cannot consent for them. And it comes up with, like, the bleeding on the table situation and emergency options for admission when no one has done any planning for consent. So what is a care facility? Generally, a care facility is the facilities that are licensed under the Community Care and Assisted Living Act, but includes some other stuff. It includes private hospitals licensed under the Hospital Act, and it includes extended care facilities and other kinds of facilities like rehab facilities. There's not group homes. So it doesn't include the community living framework, but it includes some other facilities to treat people for other kinds of health issues other than what we think of as a long-term care home. The policy gives you a lot of details on what kinds of facilities are covered. So the basic framework is that an adult can be admitted if someone consents, and there are kind of three ways to consent. One is the person consent for themselves. They might be there with family, but they understand things. They are presented with the plan of admission, and they are like, yeah, I want to live in this place. A substitute decision maker could consent if the person is incapable and they've been given authority to do so. That doesn't just mean the person waiving a power of attorney, like they have to have authority. And you don't just take their word for it that they are incapable. You have to go through a process. or the adult is admitted under emergency provisions. And there's two ways to do that. And I'm going to explain those in a moment. So the emergency provision framework, there's two ways of doing it. One is under the community care and assisted, under the Healthcare Consent and Care Facility Admission Act. So the adult is incapable of consenting, and immediate admission is necessary to preserve the adult's life, to prevent harm, and to prevent harm to someone else. Similar to other legislation, you might recognize some of that language. Or they can be admitted under the Section 59 of the Adult Guardianship Act if there are concerns about abuse or neglect, and the designated agencies, which is mostly the health authorities, are trying to intervene to protect that older person. The thing to be aware about emergency admission is it's temporary. So you can't get someone in there and keep them. I have written down the exact length of time. I think if you admit an adult under the legislation, you need to make, if it's under the Care Facility Admission Act framework, they need a permanent plan in place within 72 hours. And if it's under the Adult Guardianship Act, really it's up to the designated agencies to take proper steps to get a support and assistance plan put in place. You can't just keep someone languishing under emergency powers. So we would expect, we don't have firm rules, but we do have the decision of the Supreme Court in AH and Fraser Health indicating that this is very much a short-term measure. And if they're admitting under this, they have to be going in very quickly to get a support and assistance plan. So if an adult is incapable of consenting, that doesn't mean somebody says, hey, they're incapable. There needs to be an incapability assessment. Now, the director of the facility can do the assessment if they meet the criteria under the legislation, but usually the incapability assessment is being done by someone else, like a social worker or an occupational therapist. It could be a physician, but it needs to be somebody who's been properly trained in how to do this. But it has to be an incapability assessment for long-term care. So an incapability assessment for financial decisions or for instructing a lawyer, that does not prove they're incapable of care facility admission. It needs to be a care facility admission incapability assessment done in accordance with the rules set out in the regulations. So a lot of the consent rights, they're very similar to the consent rights under the Healthcare Consent and Care Facility Admission Act. So there's accommodation of communication needs. You know, like my family member with expressive aphasia, he would be entitled to have me sit there with him and listen to the care facility proposal, help him understand it, help him say what he wants. Consent has to be voluntary. So if there's somebody saying, you know, we're going to not let you see the grandkids unless you agree to go into long-term care, that's not voluntary, right? People have a right to information. The facility needs to tell them the rules and what can be provided in that facility so they can make an informed choice. And if there's a talk about restraining them under, say, a dementia ward where the doors are locked, that's a separate admission under the healthcare consent legislation, because that's agreement to a restraint, and that requires a different additional process. People have a right to support with decision making. Sometimes they need help, and they can accept orally in writing, or you can infer from their conduct. But you kind of work around people's disabilities to make sure that they can have as much autonomy as possible given the challenges that they're living with. Incapability assessments can be redone, but they would often be done at the time of admission, and they shouldn't be routinely done for everyone. Because remember that presumption of capacity I talked about earlier, facilities would only do an incapability assessment if there are red flags that that person does not have capacity. You know, like, and they cannot know who they are, but still understand a care facility admission proposal. It's like, if they think they're going to Playland, they don't understand what's going on. You know, if they think they're visiting their children and they're on vacation and it's just for a few days, they don't understand. But maybe they think they're poor and they're rich. Maybe that's not relevant. You know, it's, do they understand the care facility admission proposal? Now, for continued residents, sometimes people decide later they want to leave the facility. Could be they're not happy there. And so if they were There can be incapability assessments done periodically while that person lives there. There are rules in the practice guidelines and the policy about how often those will be done. And I think there's a plan to put more in the legislation or the regs, but for now, the understanding is that you wouldn't be doing an incapability assessment every day. If someone has dementia and they get up every morning and they're like, I want to go home. You know, the practices, they would be done up to like every 90 days, but that's not in the legislation. But these incapability assessments are only done when capacity is in doubt, right? They should not be used as a tool for controlling people who understand what's going on. Who assesses incapability? There's a whole list of health professionals that can do it, but they need to understand, they have to have training. And if someone is consenting, they need to understand what they're consenting to. So the legislation actually sets out what informed consent means in a care facility admission context. Remember, I said there are different capacity standards for different kinds of decisions. For care facility admission, they need to understand all the relevant information in the care facility proposal, and including when they can leave the facility, because that tends to be a bone of contention. Different people can make decisions about care facility admission for someone else if they have authority, and only if they have authority. So it could be a legal substitute decision maker like a guardian or maybe a representative, but if it's a representative, there needs to be a Section 9. Those of you who work with representation agreements, we talk about a Section 7 standard and a Section 9 non-standard. It's more complex, more invasive decisions. You need a Section 9 for care facility admission, though not for group homes. If you have a substitute decision maker, they need to have the right authority. Remember, like a power of attorney makes financial decisions and property decisions, maybe legal decisions. They never make healthcare or care facility admission decisions. They might make decisions about paying the bills, and that can create a problem, but they cannot, an attorney cannot admit somebody unless they're also a representative or a guardian of the person. That you don't have anybody to make decisions for you, you've had incapability assessment, and you just cannot make your own admission, then there are people who can make decisions for you even if you haven't done advanced planning. And the legislation sets out like a default list of people. Like the Healthcare Consent Act, it starts out with, you know, your spouse and adult children, all the way down to neighbors and close friends. And then if there's nobody, they will contact the PGT to see if they will either make the decision or find someone to make the decision. And that might be a slow process, so you might be patient with that. We want to say that the whole framework doesn't align very well with a lot of the practices in Indigenous communities. So I think that's a problem, and hopefully law reform is going to address that, but you might find that's an issue with some of your clients. There are duties to substitute decision makers. And it's the same if it's healthcare consent or care facility admission. It's not you do whatever you want. You have to be consulting with the adult about what they want. When you lose the right to make your own decisions, you don't lose the right to participate too. So you have a right to consult as much as you're able to, and that person has to consult with you. They have to follow some of their current or pre-expressed wishes. The one that they don't is you can't bind your decision maker in advance to not put you in a care facility. That's the one. Like, you can say, I really don't want to, or you can say, I want to be in a care facility with a garden, or you can have pets. You can give stuff to help them with the decision, but you cannot bind them in advance to whether or not they can admit you. But they need to make a decision that considers your best interests, and like with guardianship, the least restrictive options. You're not putting someone in a locked dementia ward if they don't have dementia. We have a few videos and I have some brochures. So we have 3 animated videos that are on healthcare decision-making for people living with dementia. They're on our website. They're for free. You can watch them with your clients if you want. They're 3 minutes long and each in super plain language. And I also have some brochures and I've brought them with me. So just come to the table there afterwards if you would like some copies. We have them in 4 languages. It's all available for free from our website too, if you want to show it to clients. And the final slide that you'll get in your package is just how to reach me if you have some questions or want to be referred to other resources. And I'm just going to pass it on to. Your slides?
Yeah, I need to put them up. Okay, I don't need the notes. Thanks, Krista. You're such a great expert, and I will have questions for you afterwards. Okay, so we're going to talk to you today about federal pensions. My name again is Marie Noel Campbell. Sorry, I'm with Seniors First BC. I'm a lawyer and the executive director of this organization. My part will be mostly to talk to you about our organizations and what we do and what's new. And then Nigat, who's been a legal advocate with Seniors First BC for about 12 years now, will talk about the substance. Okay, so we're a charity that provides information and support to older adults across BC and people who care for them. We have 4 main programs, and I'm going to go over each of them. The Seniors Abuse and Information Line is our largest program. If you don't know where to go when it comes to seniors, you can always refer them to the Seniors Abuse and Information Line. It's basically a call center. It's 7 days a week, except on statutory holidays, from 8 a.m. to 8 p.m., except on weekends where it's 10 to 5, and we have live interpretation available on weekdays. So that's a safe place for older adults and those who care about them to talk to someone about situations of abuse and mistreatment. So it can be any issue that affects them, whether it's abuse, physical abuse or emotional abuse. They can provide brief safety planning. They can refer internally or externally to various resources. They have assisted people who are looking for cooling centers during the heat waves or had questions about vaccines, or when people come to us and they have issues with their housing, they can give them some information, then refer them to our legal advocacy program. So again, if you don't know where to go, where to refer people, you can always send them to SAIL and they will help them find their way to the most suitable agency. So you'll also have a copy of our slide. That's the number to reach SAIL. Now we also have a victim services program. That's more of a case management program for older adults age 50 plus who have been victims of abuse, family and or sexual violence. They offer safety planning, and unlike SAIL, it's over the course of many phone calls. So it's more than just over the course of one phone call, there's some follow-up. They can liaise with the justice system personnel. They can do assisted referrals, but they will not report. So if someone needs help talking to the Crown or talking to the police, they will help them reach them, but they will not report on an older adult's behalf. And we have legal services for people 55 plus. Now we're going to lower that threshold for Indigenous people because we are realizing that Indigenous people have a lower life expectancy and we should match that. But for people who are low income with various legal issues, it goes from summary advice to full representation, and we also provide advanced planning services. So we help with residential tenancy issues, that will be with Nigat, who's our legal advocate. Issues in long-term care facilities, we can help with debt issues, government benefits, that's again Nigat, financial exploitation, so someone who's misusing a power of attorney, a child who's stealing from their parents, guardianship, incapacity issues, age discrimination. So if it's more discrimination in general, we will look at referring someone to class or to a local agency. Advanced planning, so wills and powers of attorney and other elder abuse issues. However, we do not assist with family law or criminal law issue. That being said, if someone comes to us with those issues, we will try to provide them with a brief consultation and refer them to another agency that can better support them. We have community legal clinics, so that's in the Lower Mainland. And this is to receive consultations in person as well as advanced planning. So people who need wills, powers of attorney or representation agreements. And we have just expanded them to Prince George and Nanaimo. However, in Prince George and Nanaimo, it is just for advanced planning, not for consultations. If people live in Prince George or in Nanaimo, they can still call our office and we will try to assist them as best we can over the phone or over Zoom. And we are hoping to continue to expand in other areas, including in Haida with people who are here in the room, Eve and Haley. We're hoping to soon be able to provide advanced planning documents for Indigenous people on reserve. So coming soon. And if you know anyone who's an expert on offering advanced planning services to people who are Indigenous and on reserve, please let me know, because we want to talk to them about setting up training, not only for our lawyers, but for pro bono lawyers going forward. These are our eligibility criteria. So generally 55 plus, as I said, we're looking at lowering those criteria for people who are Indigenous, and the income ceiling is $40,000 gross per household member, plus $10,000 per additional household member. And for full representation and for advanced planning clinics, we have an asset test of $150,000 maximum, but we provide exceptions on a case-by-case basis. So people who have disabilities and who have a mobile house, a mobile home that's valued at $300,000, for example, we may be able to help them. Last but not least, we have a public education and outreach program. We offer workshops on elder abuse issues, tenancy issues. We do that for the public and for community agencies. If you think that's something that could be of interest to your organization, please feel free to contact us. One of the publications we're currently working on is updating our legal issues and residential care manual, and Krista will be one of the legal experts we'll consult for that. And again, remember, if you don't know where to go, feel free to call SAIL and they will know where to redirect you. So now I'm going to let Nigat present. Sure.
So presentation outline is I am going to talk about Canada pension plan and related benefits. I will explain about old age security and clawback, income affecting the guaranteed income supplement, allowance and income test, property tax deferment. So Canada Pension Plan retirement pension provides a monthly benefit to those Canadians who have valid contributions into Canada Pension Plan. The amount of Canada Pension Plan depends on earnings and valid contributions. Valid contributions could be either from your work or could be from credit splitting from your former spouse or common law partner at the end of a relationship. Contributor may qualify to receive both a CPP retirement pension and a pension from the other country, which Canada has a social security agreement. And the list of all those countries is at the website of Service Canada. International Security Agreement and Canada Pension Plan Retirement Pension. If a contributor has worked in another country which has a social security agreement with Canada, then the pension credits from the partner country could help the contributor to get combined benefits to meet the minimum eligibility requirement under CPP legislation. And the International Security Agreement applies not only to CPP, it also applies to CPPD and also to the old age security. CPP retirement pension amount for the year 2022 is maximum amount is $1,253.59, and the average monthly amount paid to someone could be who is 65 could be $727.61. The amount of retirement pension depends that how much you have contributed and how long you have contributed into the CPP plan. Contribution determines benefit not only for the contributor, but also for the family members, and we will see in other slides. The minimum earnings of $3,500 has to contribute into CPP plan. Here in this slide, you will see that anyone who is between the ages of 18 to 70 earning more than 3,500 has to contribute into CPP plan. I will say that it is not 70, it is 65. That is a typo. So please forgive about that. The contribution rate is 9.9%, which is split half and half between the employer and employee. Age also affect the amount of retirement pension. The standard age is 65. However, the contributor may choose to get pension as early as at the age of 60. If the contributor wants to take Canada pension, retirement pension at age 60, there will be 36% reduction in the amount which the contributor could receive otherwise at the age of 65. The amount of pension is reduced at the rate of 0.6% each month before 65th birthday. If contributor wants to take CPP after age 65, then the monthly amount will increase 0.7% for each month after age 65, which means the retirement pension at age 70 will be 42% more than the one if receiving at age 65. So what happens with the CPP if contributor dies before receiving the retirement pension? So if the contributor dies after turning 70 and never applied for CPP benefits, then the estate can submit an application within 1 year of the contributor's death, and Service Canada can pay up to 12 months of the contributor's retirement benefit to the estate of the deceased contributor. If the deceased contributor has made valid contribution to CPP and dies either while receiving CPP or prior to receiving CPP, the spouse or common law partner can apply for a CPP survivor's pension or allowance for survivors, and the children benefit if the children are under the age of 18. So this slide shows that these are the benefits within the umbrella of Canada Pension Plan. Retirement pension and Canada Pension disability is for the contributor, whereas survivor's pension, allowance for survivors, children benefit, and death benefit are for the family members. So survivor's pension is paid to the person who at the time of the CPP recipient death was legally married or living in a common law relationship, having lived with that person at least 1 year. If the contributor has a separated wife and was cohabiting with a common law partner, then it will be the common law partner who could qualify for survivor's pension. And only one survivor's pension is paid if the contributor, only one survivor's pension will be paid if the CPP contributor was widowed more than once. So how the survivor's pension is determined? So there are factors: the total contributions of deceased contributor, the age of the contributor at the time of his or her death, and the contributions at the time of contributor's death. How other benefits affect the amount of survivor's pension? So surviving spouse will get 60% of survivor pension if surviving spouse is not receiving his or her own CPP retirement pension. If the surviving spouse is receiving his or her own CPP retirement pension, then the survivor's pension will be combined with the payment as a single payment. Combining the amount of survivor's pension and other benefits. So if they are surviving spouse is the recipient of CPP, then the combined amount of survivor's pension could be equivalent to the maximum amount of CPP, which is $1,253.59. And if the surviving spouse is receiving Canada Pension Plan disability, then the combined amount of survivor's pension could be equivalent to the maximum amount of CPPD, which is $1,457.45. Survivor's pension by age. Age 65 or more, the surviving spouse will get 60% of the survivor's spouse if the surviving spouse is not receiving his or her own CPP. So there is like the amount which we have explained in that slide. Age 45 to 65, the surviving pension on its own would be 37.5% of the total calculated retirement pension of the deceased contributor plus a flat rate, which is for 2022 is 197. So we have just calculated in this way that 37.5% of 1,253.59 plus 197 is equal to 667. It does not mean that it applies to all those surviving spouse. It is just an example which we have just explained here. Similarly, under age 45, it will be 1 out of 1/20th for each month the spouse or common law partner is under age 45 and is not disabled and not raising a dependent child. Under 35, there is no survivor's pension. If the surviving spouse is 35, he will not or she will not qualify until he or she reaches the age of 65. Allowance for survivor is paid to the surviving spouse when spouse or common law partner has died. And since their death, the surviving spouse has not remarried or entered into a common law relationship. The ages is 60 and 64. Between these ages, allowance for survivor is provided by Service Canada. And surviving spouse is either Canadian citizen or a legal resident. Surviving spouse resided in Canada for at least 10 years before qualifying for the allowance for survivor. And the surviving spouse income must be less than $47,984. Here is the scenario. Mary is age 62, living on a low income, and her spouse has passed away. Mary has not remarried or entered into a common law relationship since the death of her spouse. As she is a Canadian citizen and has lived in Canada for more than 10 years, since the age of 18, Sonia, who works for a senior organization, determines that Mary may be eligible for the allowance for survivor. Amount of old age security. So old age security is determined on the residence, age, legal status, and residence history of those who are Canadian or permanent resident. Full old security is paid to the recipient if that recipient has lived in Canada for at least 20 years since turning 18. If the recipient has lived or worked in a country with which Canada has a social security agreement, then the recipient may still qualify to receive the partial old age security, even the recipient has not lived in Canada for 10 years. If the recipient has only lived in Canada for past 10 years at age 65, the recipient will qualify only for 1 out of 10 as a partial old age security. The recipient of partial old age security will only be paid outside Canada for the month the recipient leaves, and then that the recipient will get the old age for 6 months, and after that it will stop. If the recipient does not inform Service Canada about his absence for more than 6 months, then Service Canada will stop further payment and can ask to return the benefits if given during that period. Some scenarios. So Umar was born and lived in Canada all his life. When he turned 65, he could qualify for full old age security pension. Whereas there is another person, Doris, was born in Portugal and has lived in Canada for a total of 8 years. Her income in Portugal can be counted to meet the 10 years residence requirement for the old age pension. At age 65, she will receive a partial pension. Doris was born in Portugal and has lived in Canada for 8 years. Due to Canada agreement with Portugal, she could use 2 years of her time spent in Portugal to meet the 10 years minimum residence requirement for the purpose of old age pension. As a result, Doris received 8 out of 40 as a full old age pension. Sonia, who is a worker, she determines that both Umar and Doris could qualify for old age security, but based on their specific situation. Clawback of old age security. The government clawbacks old age security if the recipient net income exceeds the threshold of $79,845 for the year 2021. The amount of clawback is equal to the recipient's old age security payment or 15% of the amount by which the recipient net income exceeds the threshold, whichever is less. And we have given an example here on the slide. So if the recipient of Canada Pension Plan and Old Age Security decides to live outside Canada, and we had seen in our work that some of them, they decide to live in the country of their origin and move out somewhere else, then in that case, there is a tax which will be deducted or withhold from their CPP or old age security check. The tax rate is 25% unless exempted by a tax treaty between Canada and the other country where the person lives. Guaranteed income supplement provides a monthly non-taxable benefit to those who are the recipient of old age security and they live in Canada. Here is the slide which we have copied from the website of Service Canada, and it explains about a specific situation, whether someone is living in a common law relationship or with a spouse or single, then how much that person could qualify as a single or living with common law, and when both are receiving benefits. So this slides explain about that. So here I'm going to explain income which could affect guaranteed income supplement. The income which will affect GIS, it is like retirement pension, superannuation, any rental income, cashing your RRSPs when receiving guaranteed income supplement, capital gains and taxable savings. When I say taxable savings, it does not apply to tax TFSA. Spousal support, workman compensation benefits, employment insurance, and returning to work. And it is exempted up to $6,000 as an earned income. The income which will not affect war veterans allowance, death benefits, inheritance, GST credits, welfare payments, registered disability saving plan, child tax benefits, and lottery winning. Some scenarios, Maggie is applying for old age security. She lives in Canada and she has little income. Sonia, who works for an organization, then she thinks that Maggie may be eligible for the guaranteed income supplement. Sonia reminds Maggie that once she starts receiving GIS, if Maggie leaves the country for more than 6 months, Maggie GIS payments will stop. In addition, to ensure that Maggie payment of the GIS is renewed every year, Maggie must have to file her income tax returns on time. This slides I have added to this presentation because we had seen people when they don't know what to do when they lose their income. So contact Service Canada for instatement or reinstatement of GEIS when someone has lost job and they have no more income coming. If because of illness they are not returning to work, or if they were outside the country for more than 6 months and now they are returning to Canada. GIS and sponsored immigrants. So sponsored immigrants who have resided in Canada less than 10 years after the age of 18 are not eligible to receive old age security income tested benefits, which are GIS and allowance for the survivors during the sponsorship period, unless the sponsor either suffer personal bankruptcy or imprisoned for more than 6 months, is convicted of being abusive towards that, or dies. Allowance. So allowance is a benefit available to low-income seniors age 60 to 64, between these ages, who are the spouse or common law partner of a guaranteed income supplement recipient. Recipient of the allowance must be Canadian citizen or permanent resident and must live in Canada for at least 10 years, the time they qualify for allowance, and must not be under the sponsorship agreement. Allowance payment will stop when the recipient of allowance turns 65, because the standard benefits, which is old age security and guaranteed income supplement, those will be given to that individual. Allowance is only paid when that person lives in Canada.
So then what you're saying is that in this case, for allowance, you have to be between 60 to 64. And then once you pass to 65, then that's when it stops.
Yes.
Okay, so I just need to understand why the benefit is only available for that age.
Allowance is paid, I will give an example, and usually I give in my presentation that suppose I am 65 and I am the recipient of old age security and guaranteed income supplement. My spouse is 62 years old and we are low income. So for that reason, my spouse who is 62 years old will qualify for the allowance. As soon as my spouse is going to turn 65, then allowance will stop and my spouse will start receiving the old age security and guaranteed income supplement. It is just like boosting the families with the benefits, like how Service Canada can support those families who are low income. And for that reason, this benefit is available to the spouse of that person who is already receiving old age security and guaranteed income supplement.
So it seems like both are kind of semi-retired. Is that correct? Or are they actively working?
If their income is below the threshold.
I see.
Yes, if the income is like higher, then they will not qualify. I think in one of my slides, I said it is $27,000 some $100. Maybe it is coming, or maybe it has like already been discussed, but it is around $27,000 some $100 when the family will qualify for the allowance.
Thank you.
Thank you. So here it is. So John is 60 years old and married to Maggie. Maggie is 65 years old and receives both old age security and guaranteed income supplement. John has legal status in Canada and lived in Canada for more than 10 years since the age of 18. Sonia, who works for a senior organization, determines that John may be eligible for the allowance. Sonia reminds John that once he is in receipt of the allowance, if he or Maggie leaves Canada for more than 6 months, John allowance payment and Maggie guaranteed income supplement will be stopped. Sonia also explains that the allowance will no longer be paid once John turns 65 years old and becomes eligible for old age security and guaranteed income supplement. I think, Emma, here, this example clearly shows that how the partners they are eligible for the allowance. When one is receiving old age security and guaranteed income supplement, and the other is between the ages of 60 to 64 and are low income.
I'm also wondering about the person who leaves Canada for more than 6 months. So this is like the example you were giving about Portugal, right? Like the person who lives in Portugal, then she goes back to her country, lives there for 6 months, and then if she overpasses the 6 months, that's when Canada can do something about it, right?
Yes, I will say in a way, I will go back and say that, okay, if there is a person who is the recipient of partial old age security, then in that case, if the person leaves Canada for 6 months, old age security is paid. Guaranteed income supplement is paid. But if that person who is the recipient of partial old age security, then overpassed 6 months, then neither that person is eligible for old age security nor guaranteed income supplement.
And then the government will stop that process immediately.
I will say that if government does not know, sometimes the government recipient, they don't inform government, maybe they don't know, or maybe they don't inform. If any amount is paid after 6 months and they were the recipient of partial old age security, Service Canada has a right to ask for the return of those benefits which were given over 6 months.
And how are they supposed to show it to prove that they did not overpass the 6 months? Like, I mean, you just said they may not ask for it, they may not know how it happened. And so say, for example, I leave Canada for 6 months and then I overpass the 6 months. Then I return, say, on the 7th month. How would Canada know? Do they have to check my documents of travel? How does that happen? Thank you.
I had seen in my work that there is another branch of Service Canada which aggressively, I don't know how they come to know, but Integrity Service is another department of Service Canada which keeps an eye over the payments. And if in case that there are some doubts that this person has lived outside Canada for more than 6 months, they start investigation with the Integrity Service. And then the Integrity Service asks the person to provide all the proofs, which could include that which address that person was living, the passport, and the record from the CBSA, Canadian Border Services Agency, when he exited or entered into Canada. Because since 2000, after 9/11, all the exits and entries are properly documented by CBSA. So in Seniors First BC, we have a lot of clients who experienced such kind of situation intentionally or unintentionally, and we have to help them.
Just to add the things that do not affect the amount of the supplement, and it would be on-reserve tax-exempt income does not affect the calculation of the supplement.
Can you keep, yes.
Oh, hi, sorry. I want to go back to what does not affect the calculation of the GIS amount. So what does not affect it is income earned on reserve tax-exempt income will not affect that supplement. Just add it to the end of your list, I guess. And also any income that comes from on-reserve income also does not affect the supplement.
You're talking about this one?
Yeah, under the not affect. It should be on-reserve tax-exempt earnings plus any money that came from those tax-exempt earnings. So CPP retirement benefit, if it comes from reserve earnings, that won't affect the calculation either. There's a whole stream of
CPP?
Mm-hmm. Retirement pension.
CPP retirement pension, are you saying that CPP on-reserve does not? Okay.
If it came from on-reserve employment, it would not affect the supplement amount.
Thank you very much. Yes, thank you. Yes, we
Sorry?
will add into the slide. Thank you so much. Yes, thanks. Involuntary separation and amount of guaranteed income supplement and allowance. So involuntary separation is a situation which is beyond the control of the spouses. And it happens when one of the spouse has to move to a care facility and the other spouse has to live independently. So if one spouse or common law partner is moving to a long-term care and they are no longer living together as a couple, then the partner not moving to the long-term care needs to submit the involuntary separation form with Service Canada to receive a high rate of guaranteed income supplement or the allowance, as the case may be. So this is the information which we pass on to our clients, and mostly we have seen when one of the partner is moving to the care facility and the one who is left behind, then that spouse does not have resources to live. So when the person who is left behind, he or she submits the form, then the guaranteed income supplement amount is given as a single person. And it increases the amount of guaranteed income supplement. Property tax deferment. The owner must have lived in British Columbia for at least 1 year immediately before applying for this property tax deferment. The owner must be 55 in the calendar year in which he or she is applying. A surviving spouse of any age or a person with disability could also apply for property tax deferment. And the owner must have maintained a minimum 25% equity to the current BC assessment value of home after deducting all outstanding mortgages, line of credits, and other charges. So property tax deferment, like which properties come within the this policy of provincial government? So an area of land with house or modular home on it, or a manufactured home, and the area of land on which the manufactured home is located is owned by the same person. So here is the scenario. So Maggie is 65. BC assessment value on Maggie home is 1 million, and Maggie taxes are 7,000 per year. So Maggie wants to stay in her own home until the age of 80, when Maggie wants to downsize. If Maggie deferred taxes throughout, which is 15 years period, then 7,000 multiplied by 15 years, it is 100,000, 105,000. And if we assume that there is 1% interest on deferment, it could equate to 8,400 in interest. So Maggie total owing to local government would be $113,400. And this is just an example we are explaining here. It means that, of course, the house may have equity. And when Maggie is going to downsize, of course, if in case that any person after the death of Maggie is going to inherit, they have to pay the property taxes first before anything happens to them. So what are the advantages and disadvantages of property tax deferment? Advantages are, of course, an increase in household cash flow, lifting pressure on mortgage payments, freeing up finances to do home repairs, and low interest rate that is not compounded. Whereas there could be disadvantages of declaring property tax deferment. Of course, it is a lien on the property, and there must be minimum 25% equity requirement, which is related to BC assessment, and a possible option when there is a time either to renew or refinance the mortgage. So instances of non-eligibility for property tax deferment. When current year property taxes have already been paid, debt owing from the previous year, which could be the utility bills, or if the homeowner grant was unclaimed, if there is a duplicate indivisible title exists on the property, second residence, which is cottage or summer home, etc., and property taxes to the residents paid to a First Nation, a property is leased from a First Nation municipality or the Crown, manufactured home with the current year fire insurance if it has not been purchased, manufactured home with no land value from BC assessment. Property title is entirely in the name of the executor or administrator of the deceased estate. Property title is entirely in trust. Property leased from the crown or municipality. Property title is entirely in the name of a corporation, float home, etc. So these are the properties which are not eligible for property tax deferment. So thank you so much. If you have any questions, I am here to answer.
Thank you. So then, this is in the scenarios that people are owners. What about if there was a scenario where they were only renters?
Property deferment?
Yes?
Owners, only owners.
Only?
Yes.
Okay, perfect. All right. So that answers my question.
Any other questions for any of the other speakers or for Nigat?
Thank you so much.
All right.